Judgment in the matter of Stevens against Hotel Portfolio and another.
On the 25th of March 2008, there was paid into a nominee account of a Mr Ruhan the sum of £95 million. It represented secret profits which he had made by abusing his position as a director of the appellant company Hotel Portfolio 2 UK Limited, which I'll call HPII, in breach of the fiduciary duties which he owed to that company as one of its directors. He had arranged for HPII to sell its chain of London hotels to a company of which he was the concealed owner, and then on-sold them with the benefit of planning permission for residential development for a vast profit. The respondent to this appeal, Mr Stevens, dishonestly assisted Mr Ruhan in concealing his identity as the owner of the buying company. Beginning a few days later, Mr Ruhan dissipated the whole of the £95 million profit by using it to repay loans outstanding on unsuccessful property developments of his in Qatar, and none of it can now be traced. Mr Stevens also dishonestly assisted Mr Ruhan in that dissipation. When the liquidators of HPII later found out what had happened, they sued Mr Ruhan for an account of the £95 million as secret profits and sought compensation for the loss caused to HPII by its dissipation. The trial judge ordered Mr Ruhan to account and Mr Stevens to pay £95 million in compensation. Mr Ruhan proved not to be good for the money, but Mr Stevens appealed. He said that if you looked in the round at the original abuse of fiduciary duty giving rise to the secret profits, together with the breach of trust consisting of their dissipation, HPII had suffered no net loss. It wouldn't have made those profits itself. The sale of the hotels was at their then market value, and the dissipation of the profits merely cancelled out a temporary windfall for HPII if it had been entitled to the secret profits in the first place. The Court of Appeal agreed with Mr Stevens and allowed his appeal. The liquidators appealed to this court. By a majority of 4-1, we allow the appeal from the Court of Appeal. I give the lead judgment with which Lord Breed, Lord Hamlin and Lord Richards agree. Lord Burrows gives a dissenting judgment in broad agreement with the reasoning of the Court of Appeal. The appeal raises the following three questions. 1. Can the court order compensation for loss caused by breach of a constructive trust of secret profits? 2. Did the dissipation of the £95 million cause HPII any loss? And 3. Even if it did, can Mr Stevens set that loss off against the gain made by HPII by having the £95 million treated as having been obtained for its benefit? The reasoning of the majority may be summarised as follows. The key to an understanding of the outcome of the appeal lies in recognising that secret profits wrongly made by a trustee or fiduciary, such as a company director, are treated by equity as held upon a constructive trust for the beneficiary, in this case HPII, from the moment of receipt by the trustee. This has been the law for some 300 years. The constructive trust is a real trust, not just a convenient label for proprietary remedies. It means that the profits are the beneficiary's property from the outset. If he knew about them, the beneficiary could say, "They are mine," and it makes no difference that the beneficiary would not have made those profits itself. Dissipation of the secret profits by the trustee is a breach of that constructive trust. If the beneficiary's proprietary interest in the profits is destroyed by the dissipation of them, as it was in this case, then the beneficiary has in principle suffered a loss equivalent to the amount dissipated. Compensation for that loss can be ordered both against the trustee and against anyone else who, like Mr Stevens, dishonestly assisted him in dissipating the trust property. So the answer to the first question is yes. The court can order compensation for loss caused by breach of a constructive trust of secret profits. Mr Stevens argued, however, and the Court of Appeal agreed, that in order to see whether the beneficiary has really suffered a loss, the court must compare its position with what it would have been had there been no breach of trust at all, that is, no making of the secret profits in the first place, and then no dissipation of them. In that case, he said, HP2 would now be in no different position than if there had been no breach of trust at all. It couldn't have made the profits, and its brief beneficial ownership of them under the constructive trust was just a temporary windfall before they were dissipated. For this purpose, Mr Stevens relied upon the famous House of Lords cases of Target and Redferns and AIB and Redler. The Court rejects that argument. The breach of trust constituted by the dissipation of the £95 million profit is not to be aggregated with the breach of duty by which that profit was made. To do so would deprive the constructive trust of secret profits of any useful meaning or value. Therefore, the answer to the second question is that HP2 did suffer a £95 million loss by reason of the dissipation of the profits. Mr Stevens' final argument was that equity will allow a set-off between two or more breaches of trust if they are sufficiently linked. Again, the Court of Appeal agreed. This argument called for the first ever examination by this court, or its predecessor, the House of Lords, of the supposed rule said to have been laid down by the Court of Appeal in Bartlett and Barclays Bank, that trustees may set off gains caused by one breach of trust against losses caused by another breach of trust if the two breaches arose in the same or in connected transactions. The general rule is that trustees have no such right of set-off. The beneficiary is entitled to the gains, but the trustee must compensate for the losses. But equity may mitigate the potential for harshness in this rule where a connection between the two or more breaches of trust is of a type which, on the facts, would make it inequitable not to allow a set-off. In the present case, the breaches which gave rise to the profit of £95 million were connected with the dissipation of that profit only by threads of dishonesty and greed. As Mr Stevens' counsel himself argued, they were parts of a single dishonest scheme. Dishonesty is not a connection likely to make it inequitable to apply the usual no set-off rule. Furthermore, to allow the set-off claimed by Mr Stevens would again deprive the constructive trust of those profits of any practical effect. And for those reasons, the appeal is allowed.